Good morning, everybody. Thanks for joining us. Contrary to the slide you can see on your screen, you'll be relieved to hear that I'm not the only speaker this morning. I'm joined by my colleague Alice Reeve, who's going to talk to you in a little while about issues around fire and rehire, which I can't confess to know an awful lot about. So I'm looking forward to hearing Alice's thoughts on that. But before that, I'm going to talk to you for a little bit about changes to the rules around the the checks that employers need to conduct to verify the right to work of employees in the business. And for those of you who hopefully haven't had your heads stuck in the sand, you'll be aware that things are about to change tomorrow, in fact. So quite timely, I'm sure you'll agree. So if we could move on to the first of my slides, please, Emma. So just as a reminder, just by way of background, the reason why things are changing are all to do with that horrible B word that we've all sort of we'll hope to have heard the end of by now, but this is all as a result of Brexit. So EU free movement laws have under government policy been sort of cancelled in effect, and as you're probably fully aware, on the 31st of January last year, the UK formally left the European Union. We then entered into a transition period, which ended on the 31st of December. And now for the last 6 months, we've been in this sort of transition or grace period following the transition period, during which various EU laws are sort of being run down under the Brexit process. And one of those relates to freedom of movement, which is really my particular area of interest. So EU nationals who are resident in the UK before the end of the transition period are permitted to remain in the UK, but in order to do so, they need to apply to the government under the EU settlement scheme. And the deadline for doing that is today. So really important that EU nationals who are eligible and entitled to apply do so. The scheme closes formally at the end of the day, and provided someone's made an application under that scheme and has been granted status, then they will have an immigration status that more or less replicates the rights that they enjoyed under free movement and allow them to live and work and study in the UK. And while we've been in this grace period when it's still been possible for people to make applications but haven't been compelled to under the terms of the scheme, it's still been possible for employers to accept EU national passports and identity cards as proof of right of that person's right to work. But the last day for being able to accept those documents on their own is today. From tomorrow, we get a brand new code of practice coming into force, which sets out the documents which you will accept from tomorrow onwards as proof of right to work, and EU nationals will need to show something else in order to be able to prove that they need to be able to continue working in the UK. Key sort of message to take home though, is that where someone has started work already, and you've done a compliant right to work check, as in line with the guidance as it was enforced on the day you conducted that check, then that check will continue to protect you whether that individual has made an application under the settlement scheme or not. So you can be sort of blind to whether they actually go ahead and make the application. From your point of view, so long as you did the check when they started work, before they started work, to comply with the terms of the scheme, then you'll continue to benefit from that from that protection. But anybody who you check from tomorrow onwards, you'll need to carry out checks in line with the guidance as comes into force tomorrow. So those are really, I suppose, my sort of key messages at this stage. We're now going to go on to sort of some of the details around how you conduct those checks and what those checks look like. The key sort of thing to sort of bear in mind is that there's been a lot of talk around conducting checks online, whether we need to go back and do retrospective checks. But I think really the best way to think about it is that from your point of view as an employer, nothing has actually changed, just the substance of what we're checking has changed. So we still need to carry out checks before somebody starts work. And provided we check a document that is listed on the list of approved documents, then we gain our protection under the right to work guidance. So the changes that are coming into force tomorrow really are around the substance of those documents that you can accept. So the list of acceptable documents will no longer feature EU passports or national identity cards, or indeed any of the sort of documents that were issued to EU nationals and their family members under the EU free movement regulations as were in force in the UK. So those are all gone. They will all be removed from the list of acceptable documents. And instead, they're being replaced by Irish passports and Irish passport cards, because we still recognise free movement within the British Isles. So an Irish national will still have the right to live and work in the UK without requiring any additional immigration permission. And we're also recognising, for the purposes of right to work checks, documents issued by the governments of Jersey, Guernsey, and the Isle of Man, provided those immigration documents have been verified as valid by the Home Office Employer Checking Service. So there's sort of a very, very strong message within this list of documents that free movement within the British Isles continues. So we still have free movement of some sorts, only on a much smaller scale than we did previously. The other document which is new to the list of acceptable documents is a document called a frontier worker permit, and that's a document issued to somebody who's an EU national and who, since before the end of the transition period, has been working in the UK but living overseas, so sort of commuting into the UK. And someone who does that is able to apply for what's called a frontier worker permit, and that document would be another document which you could accept as proof of right to work. One other thing that's worth flagging, and is obviously on the topic of right to work, but is not quite a Brexit thing, but actually is a COVID thing, which is that the adjusted right to work checking process that's been put in place, which allows employers to conduct right to work checks remotely, was due to end on the 21st of June, when the step 4 of the government's roadmap to lockdown easing was supposed to take place. Has actually been pushed back, not to the date in July that they're now talking about, but instead to the end of August. So employers can continue to carry out remote right to work checks by video call up until the end of August. But from 1st of September onwards, you'll need to revert to in-person checks. And if we can move on to the next slide. So as I've mentioned already, this idea of conducting online right to work checks is something that's been sort of much talked about, and with good reason, because it is something we're going to have to get much more familiar with, and will become much more common for us as employers. But in fact, it has been possible to conduct online checks since January 2019. But the reason why it's going to become more common now is that EU nationals who are granted status under the settlement scheme, in the overwhelming majority of cases, will have a digital-only status. You won't be able to see any physical documents to prove their immigration status, that they've been granted permission to remain under the settlement scheme. Instead, you have to carry out an online check in order to verify their status. In addition to that, most EU nationals who are granted visas under the points-based immigration system, so an EU national who isn't resident in the UK but wants to come here to work under a skilled worker visa or some other category, in most cases, they will only be granted digital status as well. So they won't get a physical document that proves their permission to live and work in the UK. They will also have a digital status that needs to be verified online. So for those, I mean, that's a very large group of people for whom there won't be any physical documents, we need to carry out an online check to ensure they've got the right to work. In addition to that, there's a new visa for Hong Kong residents called the BNO visa. There's the option of applying for that in a digital format only, so people holding that visa might well have only a digital status only, and the sort of the trajectory, if you like, the government's ambition is for status to become digital for everybody, and so we will come to there will be a point at which pretty much everybody has a digital immigration status. Not everybody will have a digital nationality status. That will still be proved by passports and birth certificates and things. But for those people from outside of the UK, it will be a digital status that we check, and it will be a rare case in the future, in a brave new world, in which we're able to check a physical document. I just to sort of mark your cards for a date when that might happen by, those of you who check biometric residence permits on a regular basis might notice that many of them now have an expiry date of 31st of December 2024. And that's actually to do with the security features of the residence permits that hasn't been incorporated and needs to be in there for them to be valid beyond 5th of January 2025. And the government has said that if you have been shortchanged on your residence permit, if you need one that's valid for a longer period, they will issue new ones free of charge closer to the time. But I suspect what might happen is, in order to save a bit of money, they will actually just move everybody over to digital status instead. Emma, if you can move on to the next slide for me. So those are sort of the examples of people whose status can be checked online. Some of those will only have a digital status, and that's those EU nationals, and some BNO visa holders. But in addition to that, anybody who holds a biometric residence permit, or to give this other terminology, a biometric residence card, can also have their status verified online. So you've got the physical document, but in addition to that, we've got the option of being able to check their status online. So online checks could be used for quite a large number of people, if we want to do so. If you move on to the next slide for me, Emma. And how do we go about doing this? Well, the first step is, in a way, it's a little bit more cumbersome than just checking a physical document. The first step is for the applicant to go onto their online account on gov.uk, and from there they generate what's known as a share code. They then give that share code to you as the employer, and then with that and their date of birth, you go onto the View Right to Work page on gov.uk, put in the share code, put in their date of birth, and up pops their immigration status with a photo so that you can verify them. So at this stage, the checking process is very similar to the checking of physical documents. So we check that the status allows them to do the work in question. We look for any expiry dates by when their immigration status will expire. And so that would be the date we need to carry out a repeat check. Check that the photograph on the website is of the person who's presenting themselves for work. And if all of those things are fine, if you don't have any concerns at that stage, you can either print that status page, either as or you can download it either as an HTML or PDF file, save it to your personnel files for the duration of their employment plus 2 years, for future checking by the Home Office if it's necessary, and that is your statutory excuse. And then, as it says on the final bullet point, if there is an expiry date of their immigration status, then that's the point at which you need to carry out follow-up checks. But moving on, in addition to that online process, we still have the requirement to check physical documents in probably in most cases. I mean, where most people in your organisation are British or are Irish nationals, you won't be able to carry out an online check on them. Instead, you'll be checking for physical documents. So the right to work checklist that we've got on the left is the one that's going to come into force tomorrow, replacing the one on the right, the existing checklist that you'll find on the Home Office website. And Emma, if you can move on to the next slide, those are the checklists that we'll be relying on from now on. So you've got this twin process. We're either carrying out checks manually or online. As I say, in most cases, it's probably going to be physical checks because people will be presenting British passports or other proof that they're a British or Irish citizen. And then in addition to that, still be people with biometric residence permits, and it's probably easier to copy those in lots of cases, or we're carrying out the online checks. So just going to sort of finish up with a few questions that we've been asked on a regular basis, just to sort of maybe try and head off some of the questions you might be looking to raise at the end of this session. So the first, and I think I've already answered this, is whether we need to check the settled status of any pre-July, so anybody who's started work for us already, employees from the European Economic Area. Do we need to check their status? The answer quite categorically in the Home Office's guidance is no. If you carried out checks in line with the guidance in force on the date that you carried out that check, then that will continue to protect you. The guidance then does go on to sort of fudge things a little bit and says that you could, if you want, carry out a retrospective check, but you've got to do that in a non-discriminatory manner, and you probably need to justify it as well. So in most cases, you'd probably be able to do that on the basis of business continuity, wanting to make sure that people have applied for the status they're entitled to, so that not at some point in the future we're in a situation where their status is challenged and they have to take steps to rectify that, possibly without being able to work in the meantime. So there is a recognition that some employers may want to do it, but frankly, I think if you haven't started doing those retrospective checks now, it's maybe too late to think about doing it from tomorrow onwards. It might be something that would be better as part of a sort of an ongoing process since the grace period started, although I reserve the right to maybe adjust that advice depending on a particular scenario that you might present to me. So next is the questions that we're getting quite a lot of is, what if somebody who's starting work for us tomorrow onwards can't provide their passport or ID card because they've got an outstanding application, or they aren't able to provide you with a share code, for example, because they have an outstanding application? Well, in those situations, if they made an application before tomorrow, then they will get a certificate of application as part of that application process, which confirms that. You can then contact the employer checking service with providing the details of their application, providing details of the individual, and they will confirm that they've got an application outstanding and that they've got lawful status while that application is being considered, and issue with a positive verification notice to protect you for the next 6 months. So someone could still start work while their application is outstanding, but you need to get the positive verification notice from the employer checking service first of all. Next slide, please, Emma. So then this is the biggie, and probably the most controversial. So what if we carried out the required checks, we've got our statutory excuse, but we later find out that the EEA national has no lawful status? So maybe somebody comes to you tomorrow and says, oh, you know, my supervisor's Polish. Well, I know for a fact he didn't apply under the settlement scheme. So what are you going to do about that then? Well, I think obviously you have to treat such allegations, particularly if they're given in that manner, probably a little bit cautiously. But the sort of the first line from the Home Office is that you will continue to maintain your statutory excuse if they've started work before today, and you checked them in accordance with the relevant guidance at the time. At that time, then you'll continue to maintain that statutory excuse. And then the Home Office go on to say that while there is a criminal offence for employing somebody either knowing or having reasonable cause to believe that they don't have the right to work, they confirm that that's generally reserved for the most serious of cases of non-compliance, and it's not intended for employers who've employed EEA nationals in good faith. Now, I don't know quite how reassuring I find that. Clearly, when you look at the numbers around prosecutions for illegal working, generally it is all done under the civil penalty regime, where they don't have to show any intention; they just have to show that somebody was working illegally. And the protection, of course, from the civil penalty regime is doing a compliant right to work check before somebody starts work. So if you've done that, you're protected from the civil penalty regime. So the concern then is, would you be subject to criminal prosecution? Well, I suspect not. I don't think the optics are terribly good for the Home Office, but nevertheless, it is a concern. And I suppose in recognition of that, we got some further guidance a couple of weeks ago, which I've set out on the next slide. And that's a further transitional process. So I don't know how many transitions we're into now, but we've now got a transitional process which applies until the end of this calendar year for that very scenario where somebody either tells you or you otherwise learn that they failed to make an application within the deadline. And in this situation, the right to work guidance says that you can tell the employee to make an application under the settlement scheme within 28 days and then provide you with their certificate of application. If they do that, skip to the third bullet point, then you contact the employer checking service. They will give you a positive verification notice, and then that's valid for 6 months. So you can continue employing them within that time. If they don't apply, second bullet point, then take steps to cease their employment in line with right to work legislation. Obviously, don't do that under my instruction. Speak to Alice about that, because frankly, we're all going to end up in a whole world of trouble if I try and advise you how to dismiss somebody safely. Or if at the end of that process where you've got the positive verification notice, but they aren't then able to demonstrate that they've been granted status under the settlement scheme, and the Home Office, the employer checking service, tell you that that their application's been refused, and so they can't provide you with the positive verification notice, then we're going to have to take steps to cease employment. So there is this process in place which we can adopt in cases where we do find out someone hasn't applied. Whether we apply that in every case where we just hear on the grapevine that they haven't applied, I don't know. I suppose we have to look at each case on its merits and decide just how seriously we need to take that allegation that somebody hasn't applied. If somebody comes into the HR office tomorrow and says, I should have applied but didn't, well, that's probably when we need to go down this process. But if you're hearing it as rumours, third or fourth hand, then maybe we don't. But I suspect we just have to play this one by ear on a case-by-case basis. All right, well, at the end of that I suppose, bit of a whistle-stop tour of what's changing, and on a slightly unsatisfactory conclusion, I shall hand you to Alice, and then we'll have time for Q&A at the end, hopefully.
Thanks ever so much, Tom. Yeah, I see there's quite a lot of tricky questions for you, so I'll make sure that there is time. We're going to have a change of topic, and I thought I would talk about fire and rehire, as it seems to have become known. Although in all my practicing years as an employment lawyer, we haven't called it that. It's really the practice of terminating and re-engaging, or dismissal and re-engagement, when you are looking to change the terms and conditions of service, particularly affecting large groups of staff, and where you can't get their agreement. So this has become a topic of interest, predominantly because of the increase in its use through the pandemic. The TUC did a survey in January, and 9% of workers said that they've been told to reapply for their jobs on worse terms since March, which is quite a staggering number when you think about it. And because of this proliferation really of what was a fairly established practice but probably only used in occasional cases, the unions have become very interested in it, and very anti it, and you can look to expect that if you're ever going to be using termination re-engagement over the kind of forthcoming months, that unions will be interested and essentially are trying to prohibit the process. I'm going to look at that in a little bit more detail and how you might go about it. We've seen some really high profile disputes, particularly you will have all seen the British Gas Centrica media attention, and I don't know the ins and outs. I have only read it in the newspapers, but apparently they tried to introduce less favourable terms for their engineers, so actually less pay, more hours is how it's been reported, and the GMB didn't hold back in their opinions about that. So their approach to saying that firing and rehiring is a dirty bullying tactic used by unscrupulous bosses, and there was no place in the modern workplace for it. So that created quite a lot of attention. We also saw it with British Airways, who were trying to change their staff's terms and conditions as a result of COVID, which obviously had a huge impact on the on British Airways and its operation. But that resulted in a private members bill led by Gavin Newlands MP, who was on the Commons Transport Committee, to say that he thought this practice should be essentially abolished. So that prompted the government to say that they were going to look at this. So they asked ACAS to look into it, and that's the change that we have seen recently. So Emma, if you flick on to the next slide. The government asked ACAS to essentially carry out a fact-finding exercise into fire and rehire. They didn't ask them necessarily to make recommendations, but to just gather views about how it was used and what whether there was a place for it, really. They spoke to a whole range of different stakeholders, so the trade unions, but some employer bodies, some professionals, so lawyers, the Employment Lawyers Association that we're members of, some academics. They spoke to ACAS as well. And as a result, probably not surprising given all the those stakeholders, there was no consensus view. It did confirm that actually fire and rehire is a well-established, long used thing. It's not new, it's only recently come to the fore in terms of gathering attention, but it's used by lots of employers as an alternative to redundancy, so saves jobs, where it is necessary to harmonise terms, where you've perhaps got lots of different working practices and for fairness and equity, as well as changing to meet changing operational or organisational needs. Did recognise that perhaps the pandemic had put businesses under huge pressure, and actually they needed to respond as a result, which perhaps led to the increased use of termination and re-engagement in these current circumstances, although others said that they thought it was being used opportunistically. So they also looked at whether there needed to be changes to the current framework in terms of protecting employees from being fired and rehired. And actually, they're currently protected under normal unfair dismissal legislation. So generally, when you've got 2 years continuous service. And so that is in place and has been working effectively already. So the government have looked at it. They got the report in February, but it was published on the 8th of June, and there's a Hansard debate from the government on the 8th of June as well. And Paul Scully, so the MP for Business, Energy and Industrial Strategy, reported on the government's findings, which I've just summarised on the next slide. Flick on. There you are. So it was a fairly, I suppose, balanced response, maybe not surprising. So the government made it clear that it's completely unacceptable to use the threat of fire and rehire to put undue pressure on workers during negotiations. But equally, they said it was really important to tread carefully when considering government intervention in commercial contractual matters, and recognise the fact that employers did need some flexibility. And in fact, I think they're worried about employers coming out of the pandemic and wanting to make sure that they didn't curtail their ability to make changes to their workforce if needed. and particularly to avoid redundancies and potentially save jobs. So they have said that there's no plans for legislation. So I think you can be relatively comfortable that this is not going to be vetoed. There's not going to be a ban or a prohibition on using termination and re-engagement. But the government have asked ACAS to produce some more detailed guidance to look at really the circumstances in which it would be appropriate to use termination and re-engagement. And they made the comment that they thought it should only be when other options have been exhausted. So it should be the last resort, really, and to set out some good practice. So to ensure that unscrupulous employers didn't get away with it and actually was being managed appropriately and in line with good practice. So ACAS have been sent off to come up with some guidance, and we await that. There's no timeline on when that will be, but I think we'll probably get it over the next coming up months, so we can keep an eye on that for you. So I just wanted to look at briefly what this means and what you should do. And I'm going to start off just with a cautionary tale, partly because it involves a solicitor's practice. And I just think that lawyers are always drawn to cases that involve other solicitors, firms getting it wrong. So apologies, but this is quite helpful in terms of how you can effectively use or not use termination and re-engagement. So this involved a solicitors firm, Wynn Solicitors, who tried to get their 365 members of staff to agree to a change in terms and conditions as a result of concerns about workload and work coming through during the pandemic. So this was in March 2020. They asked that all their staff essentially agree upfront to a unilateral variation of to a variation of the contracts, which would allow them to be put on furlough or 80% of pay during that time. And Ms. Catan didn't agree to it and said she would have been more willing to wait and see if it was needed rather than sort of agreeing in advance. Well, the Employment Tribunal, and she brought a claim for unfair dismissal. She didn't accept the new terms and brought a claim for unfair dismissal. The solicitors' practice argued their case, and the tribunal found that actually there was a good reason for asking for the variation. So there was a sufficiently sound business reason. So in terms of unfair dismissal, that falls into the some other substantial reason to justify dismissal. So actually the starting point whenever you're going through these is to have a clear business case and document it. But they found that the process was flawed in this case, and that actually before embarking on this, they should have, before getting to notice, they should have engaged in consultation in a proper and meaningful way. And they didn't do that. They actually only gave them 2 days notice to sign up, and also didn't offer any right of appeal. And because of that, it was found to be an unfair dismissal. So quite useful in some ways, because actually it confirmed that theoretically they would have a lawful reason if only they'd gone about it in a fairer way. So that leads me on really to just thinking about what a fair process might be. And I think, and some of the things that we might expect in the ACAS guidance, but certainly if you're approaching these things to do in the meantime, and the things that are already established out of case law that we have. So when you're considering the need to terminate and re-engage, the starting point is to work out what is your business reason? And actually it just needs to be something that is advantageous to the business and there's clear discernible benefit, but make sure that you've documented that and there's an audit trail and it stands up to scrutiny. You will need to engage with your affected employees to try and get their agreement, because actually if you can agree to the contractual change, you won't need to terminate at all. In terms of that, what that consultation looks like, if it's less than 20 employees, that's individual consultation, although you may do it in groups to start with as well. But if it's going to be more than 20, and you're in a position where you may need to terminate and re-engage more than 20 contracts, that's when that it engages the collective consultation requirement. So either you will be doing that with trade union reps or electing or appointing reps to undertake some collective consultation. So a series of meetings by which you put forward the reason and try and reach agreement with your members of staff. And as part of that, you need to consider all alternatives. So actually, what are the reasons for objecting? What are the alternatives to it before we just move to giving notice? And at that point in time, consider carefully what the reasons are, what the reasons for objecting are, and it's sort of balancing act. And have you tried to address and overcome the obstacles? It's worth understanding how many members of staff you've got who have agreed and the ones who haven't agreed, and so considering whether it's appropriate to push it through. And then it will be on their contractual notice if they haven't agreed, so giving them some warning ahead of time. And actually, as it is a dismissal, the case has reaffirmed that it's important to give a right of appeal as well. And I think from our experience of dealing with these situations, which come up fairly regularly, I think you often feel by the time you get to an appeal stage that, well, hold on, we had a good reason, we've consulted, we've made decisions, what's an appeal going to achieve? But it's a final step to just listen to the individual's point of view and genuinely consider why agreement can't be reached and whether there's another way forward here to act as a check and a balance. So if you are undertaking any process where termination and re-engagement may be required, so obviously, I'm working with a number of independent schools who are looking at pay, looking at pensions, where this potentially is coming into force, but actually any changes where you might be changing working patterns. Sometimes people have got established, working arrangements that simply don't meet the ongoing needs, and this is where you may need to fire and rehire. Say it's something that we've done regularly throughout time, but you just need to be aware now that this is likely to attract more adverse attention, and it may be that staff and their unions are more reluctant and rely on some of these comments that have been raised by the trade unions to say the practice is unfair. Having said that, there is no doubt that the ACAS report and the government's response is really helpful in actually rebutting that and saying, no, there is a place for it as long as it's used in an appropriate fashion. And so as long as you've got all of that process lined up, you should be fine. So that's all I had to say on this subject. So we've got plenty of time for Tom to answer the difficult questions.
Great, thanks, Alice. Yeah, Tom, we've got loads of questions coming in that they were coming in thick and fast during your talk. So let me just stop sharing my screen so that we can see you a bit clearer. There we go. So first question we've got is, an employee who resides in an EU country and qualifies for a frontier worker visa, can they continue working from abroad after 1st of July 2021 with their frontier worker permit?
Well, if they're working abroad, then they don't need any sort of immigration permission. That applies to anybody. If you don't set foot in the UK, then UK immigration laws don't apply, and you can carry on working. But if it's someone who is likely to commute into the UK for the occasional meeting or whatever, then they get their frontier worker permit, and that allows that arrangement to continue. That's the idea behind the scheme.
Great, thanks, Tom. And someone's just saying, can I clarify, if we have someone commencing employment after the 1st of July, but we have been processing pre-employment checks in advance, do we have to carry out the new checks if they're starting after the 1st of July?
Yeah, thanks. I mean, there are a few of these questions, so I've dismissed a couple that were asking the same question. And my guess is that this is from a school, because something I only really appreciated relatively recently is that schools are doing their recruitment now for starting in September, and by doing their recruitment now, that includes doing their right to work checks. So it is something that I've had to give a bit of thought to, and yeah, we're pretty confident that the check that you're required to do is governed by the guidance as in force on the day you do the check, not the date that the employment starts. So in theory, if you check an EU national's passport today, or if you've checked it already, but employment doesn't start until the 1st of September, that's absolutely fine. You don't need to go and do any further checks. The slight caveat we would add to that is just around the issue of business continuity, and whether at some stage, particularly if they're a teacher, there might be issues if suddenly they find that they get kicked out by their landlord, or need to go to the hospital but don't get the care that they need because they weren't able to satisfy the relevant authorities that they had status under the settlement scheme. So at the very least, I would be sort of saying, well, we note that you're an EU national. Probably not a bad idea for you to be do make sure that you apply before the end of today under the settlement scheme. You don't have to then insist on providing or obtaining proof, but at least that way you've just reduced the chances of anything horrible happening in the future.
Thanks, Tom. And someone's asking, if the checks were carried out online via a Zoom call and then scanned in, do we continue to request employees to bring the original documents in person to verify on the first day or earlier?
So this would be under the sort of the COVID concession to conducting in-person checks. So if the check was carried out between the 30th of March last year, when that arrangement was first introduced, and 31st of August this year, then you don't need to go and do any retrospective checks on the physical documents. The review of the scanned document plus the video call to verify their identity is all that you need to do. You don't need to do anything beyond that, unless you're doing the check from 1st of September onwards.
Great, thanks, Tom. And another question for you. How quickly do the employees get a share code from when they apply? So this person's saying they've been getting letters confirming they've applied, but they haven't received the share codes.
So I read this a couple of times before I understand what's happening. The share code isn't generated automatically. So when you are approved under the settlement scheme, or indeed under any scheme where you're issued with a digital immigration status, all you get is confirmation that you've been approved. The share code, to get the share code, you've got to go back into your online account, and you do that using your passport number, and then it sends a verification code to the mobile or email address that you used when registering for that application. So you go into your account using those security measures, and then you ask for a share code, and it pops up with I think it's a 7 or 8 digit code, and then you give that code to the employer, and then they put that. So you don't get it automatically on approval. I think the code only lasts for 30 days, so it's not a unique code that stays with an individual forever. It's something that's generated on a temporary basis, just for the purposes of a one-time check.
Great, thanks, Tom. And someone's saying that they've got a new starter who's got a French passport but a British birth certificate. Can you confirm if they will be required to produce EU settlement documents, or is the British birth certificate sufficient as an eligible document to live and work in the UK?
So this is interesting. So somebody who's born in the UK isn't necessarily a British citizen, but under the right to work guidance, under the right to work checklist, you can accept a British birth certificate and proof that that person's got a national insurance number. So what you've uncovered here is a little gap in the right to work guidance, which does allow you to employ somebody who might not necessarily have the right to work, but is nevertheless able to produce documents suggesting that they do. So if they've got their birth certificate, their British birth certificate, and a national insurance number document, then in theory that's all that they need. But we don't know for certain that they are a British citizen, and it might be sensible for them to apply under the settlement scheme nevertheless. I've really fudged that answer, but it's actually not that straightforward.
Thanks, Tom. And so next question is, how should an employer deal with someone whose application is in process with the Home Office for consideration, and they're looking to start employment with another company? So this person's saying they've done the online check with the Home Office, which is still pending. However, the individual is due to start soon.
I'm reading this as not necessarily applying to the settlement scheme. So if they're applying under the settlement scheme, that means they've got a EU passport. Then they could just produce their EU passport, and that would be enough for them to start work. But if they're not an EU national and they're not able to produce anything else, which as of today would demonstrate a right to work under the checklist, then you don't actually have any choice but to wait until you get that response back from the Home Office with a positive verification notice, or they're able to give you a share code or some other proof of their status. So because otherwise commencing employment would mean that don't have the statutory excuse.
Thanks, Tom. And so a member of agency staff who was on an EU passport and has got a residence document which does not have a renewal or an expiry date, they've not applied to the EUSS and is currently outside of the UK, are they able to return to the UK and continue to work? You might want to read that question yourself just to clarify that I've read it out correctly.
Well, you can apply to the settlement scheme from outside the UK, but you will generally have to demonstrate that you were in the UK before the 1st of January, and also that you've been here within the last 6 months. And reading that question, I'm not sure that they have. They might have been here before the end of 2020, but I don't know whether they will still be eligible under the scheme. So the answer is I don't know. I don't have enough information about that particular scenario. I mean, the point I made earlier about not having to have immigration permission if you're not setting foot in the UK stands, but it sounds like they want them to come back, and I don't think I can answer that.
Thanks, Tom. And someone just wants to clarify that we do not need to retrospectively check that employees who have been working for us over 2 years have applied for or obtained settled status.
Yeah, that's right. So if you've already got a statutory excuse because you checked their right to work before they started employment, then yeah, the guidance is quite clear. You don't have to do anything else. You don't have to check them again.
Okay, we've got quite a long question now, Tom, so you might want to check it and read it at the same time. So please, can you advise on what we should do if we have an EEA casual worker who may have had a right to work check carried out in the prescribed manner, but have since had their contract extended? We wouldn't normally carry out a further right to work check at the point of extension unless it was time limited, but given a casual worker wouldn't have continuity of service as such, would it be good practice to carry out a further check at the point of extension, or could we be challenged on this? Similarly, for core EEA staff, when we extend their fixed term contracts, should we carry out another right to work check at any point?
So the requirement is simply that you carry out a check before employment starts. And there isn't any deadline on that. That's why I'm quite comfortable saying that for those schools that are carrying out right to work checks now for jobs that are starting in September, they don't have to do a further check after today on the new documents. I think where someone's contract is being extended, I think that same principle applies. The thing that sort of gives me cause to think just a bit more carefully is about the issue around continuity of service. But again, I don't think that necessarily makes a difference. I mean, I think there's an argument that it would be good practice where there is a break to be carrying out a further check, or at least asking the question around someone's status if we don't think that the checks we've done previously protect us. But it's probably one that we need to think a bit more carefully about, because it's that's not the sort of thing that's generally envisaged by the guidance.
Great, thanks, Tom. And someone is asking, this is another quite lengthy question. So we have an employee who has tried to apply online for the past week, but says that the government system has changed ahead of today's deadline and they've been unable to, despite repeated attempts, to get through the 30-page application and receive confirmation. Yesterday, they said they received a message saying that they have been eliminated for 24 hours for too many attempts, such that there is a real worry that it won't get done today. On trying to call Home Office, and they have received only a recorded message to apply online and they can't get help. You mentioned a transitional period. Can I reassure them that they'll be able to apply online despite today's deadline? And do you know of anywhere essentially that they can go for help with applications or specialist agencies who provide that service?
Well, on the latter point, I mean, there's loads of people offering free and paid for assistance out there. I think a lot of citizens advice bureaus are helping, but I dare say they've probably tried a number of those. The scheme deadline is today, but the government have said that they will consider applications received late if there's a good reason for not having applied in time. It sounds like this person, if they're having technical problems or other issues, and if there is a volume of applications that are being submitted over the last few days, then they may well sort of be happy just to sort of waive or disregard that deadline, or be a bit more relaxed about those that received in the first few days of July. From your point of view as the employer, I think you're going to be moving into this sort of transitional period that I outlined in my last slide. This transitional arrangement that I outlined in my last slide. So, telling them that they need to apply within 28 days and providing you with a certificate of application, and then you use that to check with the employer checking service. So if they aren't able to apply today, it's really crucial that they apply within the next 28 days. And if they are struggling, they definitely should get some external support, because it sounds like it might be a more complicated application, by reference to the fact, because most applications are very straightforward. You don't need to apply on a paper form, but if they're being told to apply on a paper form, then that suggests it's a bit more complicated, so they should get some additional help.
Great, thanks, Tom. And somebody said one of our existing staff has an Italian passport and a certificate to confirm naturalisation as a British citizen. This is in paper format without her picture on the letter. Is that sufficient, or does the employee sorry, I can't speak to this morning. Or does the employee supposed to produce any other documents? This is something which was on the old right to work checklist, and it's on the new right to work checklist as well. A certificate of naturalisation, a certificate of naturalisation as a British citizen is an acceptable document. It isn't a document that contains a photograph, so there's nothing to be alarmed by there. But in the same way as you can accept a British birth certificate as proof of right to work, you also need to have proof of their national insurance number. So it's on the checklist, you can accept it, but you also need proof of their NI number in order to get your statutory excuse. Great, thanks, Tom. You can have a break for 2 seconds, because I've actually got a question for Alice, just to make sure that she's still with us and she's still paying attention. So Alice, somebody has said, slightly different to fire and rehire, but the question is about relocating an employee's role to a different work location. They've carried out a full redundancy consultation process with an employee, which resulted in an appeal against the relocation that was not upheld. They're currently doing a trial period working in the new location, but the manager and the employee are in disagreement over whether this is working. If they conclude the trial period was unsuccessful and they terminate employment and pay redundancy, does the employee have the right to appeal this?
So yeah, a couple of things breaking that down. So if there's no need in the place that they currently have been working, then that is a redundancy situation. Then offering it in the new location is essential as part of your duties to consider it as an alternative for them. You then come into whether, actually it's a suitable alternative that they have to accept, or whether they might be able to argue that it isn't a suitable alternative, or whether they can unreasonably refuse it. And it won't surprise you that there's lots of cases around that, but it all depends on really whether their contract's got any sort of mobility clause in, how far away it is, whether they've worked there previously, their own personal circumstances are relevant too, in terms of how they get to work, public transport, parking. So actually there's a whole lot of factors to come to play as to whether or not it's working. And ultimately it's a sort of mix between an objective test but also subjective, depending on the individual's personal circumstances. If in doubt, probably the right option is to let the employee choose to leave and take redundancy instead, although I appreciate there's probably a cost attached to that, but it would be fair. But then they would have the right to appeal. But that appeal, I suppose, in this instance would be about whether the original redundancy was genuine, and whether you'd gone about that fairly and considered all other options as well. I hope that answers the question.
Great, thanks, Alice. Tom, back to you. We've got 2 last questions. I hope you can get those in the next couple of minutes. If an EU member of staff made it clear initially that they would not be applying for settlement status, can we ask them for confirmation that they have it? Appropriate checks were carried out when appointed.
Never dull in HR, is it? Made it clear they're not going to be applying. Well, I suppose this probably comes down to, you know, an assessment of whether we think that that's likely to be the case or not. Whether they reiterate, you know, maybe they say tomorrow, you know, I told you I wouldn't apply, and I haven't applied, and I refuse to, and I disagree with this whole thing. And that's, you know, I can understand that position, although it's a slightly frustrating one. So if we are still satisfied that they've not made their application, then we probably need to go through that transitional scheme that's set out within the new guidance for employers, where we say, well, satisfy us within the next 28 days that you've applied, and you can continue working while your application's being decided. And if they haven't made an application within 28 days, then Alice can help you with their dismissal. But I think it will boil down to how convinced we are that they actually haven't applied when they should have done. You know, if it's something they said months ago, then before we know, they've changed their mind. So yeah, it will, I think, depend on, you know, more about those particular circumstances.
Great, thanks, Tom. And one last question, which is good because it's 1 minute too, so probably a good place to finish. Is the deadline for checking remote documents also applicable to other checks, i.e. DBS?
I don't know. I don't know if there's been an alternative mechanism put in place for COVID. Alice, do you know?
There has, so there is an alternative mechanism put in place, but I'm really sorry that although I should know it, there is a bit more flexibility around it, and you can do it remotely as well. I'm sorry, we'll catch your details and we'll send you the confirmation of that. But yeah, there is some flexibility as a result of COVID.